Hi, my name is Vicky Biggs and I head up Myerson's Business Debt Recovery team. In this video, I will be discussing the options available to businesses who are trying to enforce payment of business debts. A common question we get asked is, if I succeed in court proceedings, does that guarantee payment? Unfortunately, succeeding in court proceedings does not guarantee payment. If the creditor succeeds in the claim, the court will either award judgment in the creditor's favour or the debtor will agree to pay a certain amount. If the debtor still refuses to pay the debt or does not comply with any payment plan, the creditor will need to take steps to enforce the judgment or the amount the debtor agreed to pay. Unless the debtor has money, assets or income, the debt may not be recoverable. This is why it is important to investigate the debtor's ability to pay. I will discuss later in this video ways in which creditors can obtain information about a debtor's financial position. So how can you enforce the judgment you have obtained against the debtor? There are many enforcement methods available, such as instructing bailiffs to seize and sell goods owned by the debtor in order to pay the debt. This is a very popular method of enforcing a judgment debt, as it can be done quite speedily. It requires the issue of a court document, either a writ of control or a warrant of control, which allows the bailiff to take control of and sell the judgment debtor's goods in order to satisfy the judgment debt. Instructing a bailiff is a good way of satisfying smaller judgment debts because sometimes even the appearance of a bailiff at a debtor's door can elicit payment of the debt. You could also obtain a third-party debt order whereby the creditor can seize sums owed to the debtor that are in the hands of a third party. For example, monies held in a bank account can be paid to the creditor as opposed to the debtor. Third-party debt orders are not the most popular method of enforcement, as they depend on there being a third-party debt and the judgment creditor being aware of the same. You might also be able to obtain a charging order. A charging order is a way of securing a judgment debt by imposing a charge over a judgment debtor's beneficial interest in land, securities or certain other assets. If a charging order is obtained over land, this usually prevents the judgment debtor from selling the land without paying what is owed to the judgment creditor, provided that there is enough equity after prior creditors have been paid. Charging orders should not be used to enforce payment of smaller debts, as the court is unlikely to grant a charging order to secure a small judgment when the judgment could be enforced using another method. A charging order is most effective when there is substantial equity in a property and the judgment debtor is the sole owner. Please note, the process for obtaining a charging order can be slow, and a charging order itself does not realise funds to satisfy a judgment debt, as that requires a sale of the property, which does not automatically flow from obtaining a charging order. The creditor would either have to apply to the court for an order for sale or simply await the sale of the property. Charging orders can also be obtained over other assets such as shares, but this is less common. You could also apply for the debtor to be made bankrupt or wound up. The debtor's assets are then collected in by a trustee in bankruptcy or liquidator and distributed amongst all creditors in accordance with insolvency law. A note of caution: bankruptcy and winding up proceedings are expensive and time-consuming and may not ultimately lead to any recovery depending on how many assets and debts the debtor has. You could also appoint a receiver. This is a relatively unusual method for the enforcement of a judgment. The court has the power to appoint a receiver in all cases in which it appears to the court to be just and convenient to do so. This method of enforcement is usually only available where other methods of legal enforcement are unavailable. A receiver is usually appointed to assist in the preservation or gathering in of property. A receiver may be authorised to receive rents, profits and monies receivable in respect of the judgment debtor's interest in certain property, and to apply that income in certain ways, including the payment of the judgment debt. We can advise judgment creditors on the best enforcement methods available, which will depend on the size of the debt and the debtor's circumstances. So what needs to be checked before proceeding to enforce a money judgment? Before certain enforcement methods can be used, including taking control of goods and third-party debt orders, generally, the debtor must have been given an opportunity to pay the judgment debt. They must have failed to pay the judgment debt when due or failed to pay an instalment due under the terms of the judgment. The position is slightly different for charging orders. Where a debtor is required by the court to pay a sum by instalments, a charging order may be made even though there has been no default in payment. However, the court will take into account the fact that there has been no default when deciding whether to grant a charging order. This may mean that the court will not grant a charging order if the debtor has not defaulted on any payments due. It is important to check carefully whether payment is overdue under a judgment or order before you start enforcement proceedings. Before starting any enforcement proceedings, the relevant judgment or order has to be served on the judgment debtor. If the debtor is served with the judgment, this can prompt payment of the judgment debt or flush out whether the debtor wishes to set aside or appeal the judgment. Please note, enforcement of any judgment can be impacted if the debtor is challenging the judgment. If a judgment or order for the payment of money does not specify a particular time for payment, the general rule is that the judgment debtor has 14 days from the date of the judgment in which to make payment. The court does have a discretion to change the normal 14-day period. However, an extension is unlikely to be granted if there is little prospect of payment in any event. Furthermore, the court should not restrict a judgment creditor's enforcement options. The court can order that payment of the debt be made by instalments. This applies to both individual and corporate debtors. Save for enforcement by charging order, creditors cannot enforce a judgment if the judgment debtor is up to date with instalment payments. If the debtor applies to the court to be able to pay the debt in instalments, the debtor must provide evidence that the judgment creditor can expect to receive payment of the debt within a reasonable time frame. Even though limitation is not generally an issue for enforcement proceedings, delaying in enforcing a judgment can have consequences. It is important to act quickly with regard to particular types of enforcement. For example, there is no point in applying for a third-party debt order once the money has been paid out by the third party. Also, delaying gives the judgment debtor an opportunity to move or divest themselves of any assets. Any delay may also affect what may be awarded by the court in terms of interest. Please also note that permission is required to issue a writ or warrant of control on a judgment which is more than 6 years old. As I mentioned earlier, writs and warrants of control have to be issued by the court prior to a bailiff being able to seize and sell goods owned by the debtor in order to pay the judgment debt. For other types of enforcement, such as applying for a charging order or third-party debt order, the court may take into account any delay in enforcement when exercising its discretion in granting the order. Is it worth enforcing the judgment? An important question which ought to be asked before commencing enforcement of a judgment debt is whether it is worth enforcing. Does the judgment debtor have any assets against which the judgment can be enforced? This question should be considered when first contemplating court proceedings and subsequently during the proceedings. It should then be reconsidered at the time of enforcement. If the judgment debtor does not have any assets, it is probably not worth proceeding, as money spent on enforcement proceedings might simply be thrown away to no purpose. So how can you obtain information about the debtor's assets? If you lack information about the judgment debtor's assets, then there are ways of obtaining this. For example, you could ask the judgment debtor. They may respond voluntarily, or alternatively, you can apply to the court for an order to obtain information from the judgment debtor. The order will require the debtor to give answers orally on oath to a court officer. Failure to comply will result in the matter being referred to a judge who may make a suspended committal order, which could mean that the debtor could be sent to prison if they again fail to attend court to answer questions about their financial means. You could also instruct an inquiry agent to carry out inquiries on the debtor's assets. Inquiry agents can produce reports which are a useful tool for identifying the current financial status of a business or the individuals connected with that business, such as its directors. It is important to make sure the inquiry agent conducts their investigations legally. You could also check the insolvency register on the gov.uk website. This provides details of whether an individual, such as a company director, has been made bankrupt or is subject to some other kind of insolvency process. You could also conduct a land registry search to establish whether the debtor owns any property. Searches have to be carried out by reference to all addresses you have for the judgment debtor. Land registry searches will also help ascertain whether any property owned by the debtor is subject to charges such as a mortgage or other debts that the debtor owes. You could also check the register of judgments, orders and fines for England and Wales. All County Court and High Court judgments, unless exempt for some reason, from 6th of April 2006 for the payment of money, are contained in this public register and remain on it for 6 years from the date of the judgment, unless the judgment is set aside or paid in full within 30 days. You could also conduct searches at Companies House to get copies of the basic information about the company and its latest filed accounts. Obtaining the company's latest filed accounts can be helpful in identifying a company in financial difficulty. A note of caution here though, a company's latest filed accounts could be quite old, perhaps as old as 12 or 18 months, and therefore may not reflect the company's current financial position. You could also conduct searches of the Insolvency Courts, Companies House and the London Gazette, which will show whether a company has entered some kind of insolvency process such as administration, liquidation or receivership. Finally, you can carry out searches on the internet as there may be information publicly available about a debtor. If you need help enforcing payment of a judgment debt, please do not hesitate to contact me or another member of the Business Debt Recovery team by emailing us at lawyers@meyerson.co.uk or calling us on 0161 941 4000.